Brought to you by Prescient Investment Management. Informed by science, guided by insight. Prescient Investment Management is an authorized FSP.
Welcome to Honest Money. We've got a bit of a special episode today because we're talking about something at the end of life, not at something at the beginning of life. We're talking about wills, why they're important, why somebody needs them, what are these things, and so it's not really my area of focus. So I'm bringing in I don't want to say heavyweight because that sounds like he's overweight and he's not, but I'm bringing in some backup. Terence Tobin, he's the founder of Rich Ideas. He runs a financial planning business. He understands the kind of life cycle of financial planning, and especially kind of an all-round good guy because he, every year when it's Wills Week, he'll go out there and he'll, I shouldn't say forever because maybe one day he'll stop, but he dishes out lots and lots of free wills to people. It's something he deeply believes in, and to do something like that for free makes him kind of a special guy in my book. And so I'm really glad to have you on the show, Terence.
Warren, thanks very much for having me on the show.
So we're talking about wills, and maybe just to kick off, what on earth is a will?
In my mind, a will is your ultimate beneficiary nomination document. So we work hard during our lifetime. We come and have sessions with Warren, Ingram of Galileo. We create our wealth, and we want to leave behind our wealth to people that matter to us, people that we care about. And we want to make sure we do it as tax efficiently and as easily as possible.
And so it's kind of a legal document, right? It's got specific legal frameworks. When you die, the person that looks at that will that you've appointed to kind of execute your wishes, they're actually, funny enough, called the executor, and that person comes along and says, I'm going to follow obviously the law, but I'm going to follow the wishes of the person that's died, and I'm going to implement those on their behalf. And so it kind of changes your status from being obviously, one day you're alive and the next day you're dead. But what your will does is it creates kind of a new legal person, right? Estate late. It creates somebody that in law exists for a period of time, and the person that acts for that estate late is the executor, and it's their job to follow your wishes as long as let me say again, as long as it's within the law. You can't tell them to do funny things, but it's their job to kind of make sure that everything happens as efficiently as possible.
Correct. Yeah. So they step into your shoes when you're no longer here, and exactly that. They wear your hat. And within the parameters of the frameworks of the various laws, they need to now take that will and, exactly as you said, go from paragraph 1, sentence 1, and do as instructed where they possibly can. So we call that now a valid and executable will. And like you said, their role is an executor. You have the freedom of choice, Warren, that you can nominate an executor that you wish. It is recommended that that person has sufficient skill, competence, knowledge. They know what they're doing, because you don't want to run into delays. And you also have that choice to co-opt in or to make a third party an executor. This is someone now generally of legal standing or a board certified person, someone who does this day to day. And yes, they are entitled to a fee, which, yes, is negotiable. So that fee currently is set at 3.5%, excluding VAT, or 4.025, including VAT. And again, negotiable on the size of the estate, the amount of work that needs to be done, because winding up an estate is no easy task.
I think just to explain that to people, so when this starts, there is a beloved government department, as all government departments are, and that's called the Master's Office. And the executor needs to deal with this Master's Office, and they need to beg and plead them just to do their jobs, because a lot of stuff is required here, to kind of explain to everybody, whether it's banks, insurance companies, the deeds office if you own property, SIPSI if you own a company. All of these organizations now need to know that someone has died, and also who the new owner is going to be. And unfortunately, a lot of that has to go through this Master's Office, which is not a picture of efficiency. So when people say to me, gee, I don't know why on earth we would pay an executor 3.5%, I always kind of smile to myself thinking, it's it's really, I think, I can't swear, so I'm not going to, but it's really one of the worst jobs out there, because you're dealing with so much bureaucracy. Whether it's just getting banks to kind of change the account to estate late, whether it's insurance companies, whether it's the master's office, the deeds office, all of that. And in the middle of all of that is an executor trying to get it done as fast as possible. Obviously, there are people that are distraught and bereaved on the other side. So the family members are not in a good state, usually emotionally. I would hope that they're not in a good state. And then, potentially they're under financial duress and desperately need money. And if the breadwinner of the family has died, and all of this relies on the executor, who needs to rely on everybody else. So my view is, yes, Terence is right. You can negotiate the executor's fee. And if you have a very large estate, and in my mind, we're kind of in the tens to 20s of millions of rands and more, then you are entitled and should feel entitled to negotiate. If your estate's going to be 2 or 3 million rand, I think you find yourself a good executor, and you are grateful that they do the job well for your loved ones, because that's really what this is all about.
It's a job I wouldn't want to take on, Warren, even at a fee, as you said. Trying to close accounts, transfer accounts, dealing with all the red tape. It's a lot of work.
So Terence, someone's going to be listening to this thinking, I'm 23 years old. I've got no beneficiaries. I've got no kids. I've got no wives. I've got no husbands. I'm kind of footloose and fancy free. I don't own much stuff. I've just got a bit of debt. These guys are talking about wills. I mean, I don't need a will. Like, why? I've got no one. I've got nothing. What's the deal? Why do I need a will?
Warren, I think you still need to plan for that, and you still should have a will, because one day that situation can change. There's the potential for that change, and perhaps you haven't thought of it at that point in time. So, set it up now and make sure that your voice is heard when you're not here. And we have that freedom of choice. By failing to take that freedom of choice, that freedom of testation, you now leave it up to the courts, as you've said, the inefficiencies that lie within there and the delays. And there's a law in South Africa called the Intestate Succession Act. And that would govern who now benefits from your estate. And perhaps, like you said, you are 23, you don't have much. So, next in line could be your parents, whereas you might have wanted to leave it to somebody else. So I think having that freedom and being able to document what you'd like is vitally important. And we can keep it very, very simple. A will can be a 1 or 2 page document. You don't need complexity. We don't need to fill it with legalese and complicate it. And then it's something now that you've got in place. It's a foundation. And as life changes and you start growing your wealth and maybe acquire a property, etc., you can now revise and update that will, but we have something to start working with.
Yeah, and I think for me also, just most practically, if you're 23 and you think you're going to live forever, because we're all going to live forever when we're 23 years old. The one thing to know is, if you die in an accident, like, how do you want to be buried, or do you want to be cremated, or leaving it up to, again, now a government official, because that's what's happening now. You haven't got a will, so it's not just up to your family. They can't just decide. And now there's government officials involved, and they're going to decide what happens to you. And so, at its most basic level, I mean, if you just want to be sure that you're going to be either buried or cremated or whatever it is, put it in a will, write it down, give it to the family to make sure they've got copies. You don't want government officials to be deciding your fate at the end of your life. And you're not leaving behind a gift to your parents, let's say. If you die without a will, you're leaving behind a mess. And so, in short answer, for me always is, everybody over the age of 18 needs a will. That's the deal. And when you've got good people like Terence, who kind of say, "I'll help you," and every year at Wills Week he's gonna give out free wills, then take advantage. You haven't got an excuse now. The only excuse you've got is you were lazy and you wanted to leave behind a mess to your family because you didn't think about this. So this is the Honest Money Show. That was a little bit of honesty. I want to jump ahead a bit, Terence, because the thing that bothers me with when I do kind of talks to an audience of people, and I ask them to put up their hands if they are parents, and then you'll see, let's say 3/4 of the audience will put up their hands, and then I'll say, please keep your hands up if you don't have a will. and about half of those will keep their hands up. So in other words, about a third of the audience every time so far will say that they don't have a will and they've got kids. And for me, this is kind of a real tragedy we need to talk about, because one of the things you can put into a will is you can nominate who's going to look after your children if you die. If mom and dad die, let's say they die in a car accident, who looks after the young kids? Now, if you haven't written it down again, and it's not in a will, again, what you've done is you've left behind a mess. So now, is it your parents? In other words, the grandparents of these youngsters, are they now late in life going to become parents again, having to look after toddlers or teenagers? And I mean, we all know teenagers and grandparents. That's a proper generation gap. Is that a gift to the kids or the grandparents? And if it's not the grandparents, is it your siblings? Is it good family friends? All of that needs to be covered in the will. Like, if there's no money, if you've just got debts and you've got kids, doesn't matter. Nominate someone and put it down in your will. Like, this stuff needs to be thought about. The day you have your first child, that will needs to be in place. You just need to know you're doing something which is both a gift to your child and also, again, saving a hassle.
Warren, it gets me into trouble because I've been saying it every year for years. If you're a parent without a will, you're a negligent parent. And like you say, honest money, and that, I just feel like it's such a first step of the financial planning process, especially for parents. I mean, I can't think of anything worse now. Your child loses both mom and dad, so life instantaneously changes for them, and now they don't know where they're going to go and sleep that night. Who's going to look after them? Who's going to take them to school? Who's going to pay for things? And like you said, that's the most important element of the will for a parent, is who's going to look after your children physically, where they're going to be, and then how are we going to protect their inheritance? And I'm sure you're going to touch on this, but within the will planning process, because it's not a simple template, ladies and gents, we need to make sure that we plan this correctly. And a critically important part, especially for parents, is a provision for a testamentary trust. Something put in place to look after the inheritance for your kids, because again, we don't want to now lean on the courts in what's called the guardians fund. You want to make sure that money is protected and looked after. And if there's significant inheritance, unfortunately, we've seen money does crazy things to people. So leaving it to your trusted family member, I don't recommend. It's like the lotto effect. People won't make wise decisions, especially, as Warren said earlier, when we're emotional and we're distraught and life has changed forever. It's better to have a documented guide. Your will is almost it is part of your financial plan. It's a document that guides us and now what should happen in your thinking when you're not here. And as a parent, setting up who's going to be guardians and who's going to be trustees is critically important.
So let's, I think you're making a fantastic point there, Terence. So let's just kind of make a little bit of a practical example. So it's mom and dad, they're young, they don't have a lot of assets. Let's just say they've got a small home, they've got a bit of a bond. So they've got life cover. So they've got life cover to pay for the outstanding bond, so that if they die, the child will inherit a property, which is a gift in a way. And in addition to that, there might be a few more million that also get paid out as a life policy. What you're saying there is that let's just say that cash that's now sitting in a paying out to a child. Let's say a 3-year-old kid, is suddenly going to inherit, 3 million rand. That's, on the one side, it's great financial planning that you've done something and there's now a financial provision. So well done. We think that's good. But the next thing, and that's what Terence is talking about, so I think we need to unpack it a little bit, is you can put in a will that you create a legal vehicle which protects that money for the benefit of your child. So what it says is, if mom and dad die, this money, the 3 million rand now goes into something new, and it gets created on the death of mom and dad. So it doesn't exist the day before. The next day it exists, and it's this thing called a testamentary trust, right? I'm using the right jargon there, testamentary trust, Terence?
That's it, 100% right. And like you say, there's no cost for it now because it doesn't set up yet, Warren. It's not in place until mom and dad have passed. because as you quite rightly said, a 3-year-old can't inherit in their personal capacity. Imagine that, a 3-year-old getting 3 million rand. It's just not possible. So who's going to get it and how's it going to be protected?
And so it goes in there, and then who decides, who looks after that money for the child? Is that something that you write in the will?
Absolutely, yes. So there we'd have trustees. So you've got, you must have an independent trustee who understands trust law and planning and tax, etc., because you've got to make certain declarations to SARS and you've got to open a bank account. But then nominate now family that you trust, people that align to your thinking, share your values. So it could be siblings, could be cousins, your parents, or the grandparents of the child. And the purpose of that testamentary trust, Warren, is to pay what you would have paid. So it's to continue paying medical aid, school fees, clothing, holidays. And it's designed, the trustees all have an obligation, this thing called a fiduciary duty, to look after that money purely for the benefit of the child or children, and to make sure that they're looked after until a particular age. And at that point in time, now, again, the trustees would discuss with each other. And at that point in time, that testamentary trust would dissolve and that child would now receive, hopefully, those leftover millions, and that can set them up for the rest of their life.
So we're talking about, just as an example, it's not prescribed. There isn't a specific age where you say it must be closed at age 18 or 21 or something. But so let's just say that there's good planning there, and they do it to age 25. That means that the hope is that the child by then is well educated around money, understands, they're not going to blow it. I'm laughing a little bit because I'm thinking, me at age 25, if I inherited a few million rand, I'm not sure I would have been that sensible with it. But you've got to inherit the money at some point, and then you get paid that money out. The trustees don't get. It's not that they get a share of the money. They're then disclosed, and not disclosed. They've now done their job. They exit, and the young adult now carries on in life. I'm thinking, Terence, and I'm not trying to catch you out, so you can say if you don't know, but what happens if it's a house? I'm just thinking about, I created this wonderful example, and I suddenly thought, can you put the house into a testamentary trust as well?
So Warren, they'll look at practicalities of that. So we can put that house in the trust, but is there going to be sufficient liquidity and cash to sustain that house? Because it's marvelous that we now put a 2 million rand house in a trust, but that trust doesn't have the ability to earn an income or generate revenue unless it maybe rents out the house. And this is, as you said, having life cover not only equal to the bond, but at a higher amount, so that we can, 1, sustain the child, and 2, keep that property going. But that's a decision, obviously, you'll put in your will, but it will also come down to practicalities at the time, and the trustees would have to meet. They would have a special meeting, for instance, because maybe that area is no longer suitable, or the property needs major repairs, so we need money for it. So there's a lot to consider, but yes, it is. For instance, Warren, it's probably not practical to put a car in a trust if the child's 3 and to keep it till they're 25, So that kind of thing, they would try and sell it at a fair market value. But that's where the planning comes in. And again, why I'm just reiterating not to use a template. Talk to a planning professional when drafting your will.
And so as we're talking now, I'm thinking, if it's just a kind of a generic townhouse or, an apartment or something, it's probably best not to stipulate that it goes into the testamentary trust. Rather, in your will, say to the executor, I want you to sell this, it's bond free now, but I want you to sell it. And the cash goes into the testamentary trust, and then the trustees, have a lot more flexibility to manage something. So, Terence was being really nice to say, Warren, that's a stupid idea, but now we've got it. Now we've landed on somewhere good. So we're burning through our time, Terence, and I just want to make sure we're covering most of what we need to. Is there another kind of important point that you want us to tell people about before we wrap up?
Your will is not a static document. Many times I've spoken with clients who drafted their will 10, 15, 20 years ago when they got married, or when conscription was still compulsory, so just before going to the army. I met a chap, he did his will in 1981 and hasn't looked at it since. And he left everything to his parents according to that will. And now what about his wife and 3 kids? And he's got a significant estate. And legally it's going to the parents. There are provisions where the wife can submit a claim, but we don't want to complicate things. But don't think your will is done today and forgotten, especially with young children. And mine personally, Warren, my daughter's 8. We've revised our will 3 times in the last 8 years and changed guardian nominations because of age, parameters. People have moved. Sadly, one set of guardians passed away. So it's something you review and you need to change and update accordingly. But I also recommend keeping it simple. So unless there's specific need, don't mention I drive an XYZ 4x4. Just say my vehicle or my primary residence as opposed to the specific address. It prevents you from always having to update. And then remember as well, Warren, I think a big one, and I had this with a mom recently, is a nomination for guardianship is not an obligation. And we had to unpack that because she wanted to nominate certain people. And I said, but they're not at that point in time. The masters are now going to say, listen, will you take over the parenting of this child? They might decline. So always have an alternative option in your will on anybody. The executor, the trustees, and the guardians have an alternative or second option just in case.
I think it's, I actually never thought of that. And I think it's a really powerful point. And also, just to understand that, once you've got a will today, as Terence says, it doesn't need to be a static thing done for life. What will happen, it's almost the first line of every single will is, it says there was some little bit of explanation, but it kind of says all the previous wills that have been written by me are now no longer valid. And this is the one that's to the current date. That's the most valid one, and all the others are now invalidated. So you can have 15 wills all over the place, and they're not all valid. You don't have to go and find them and burn them or whatever. The most current one is the one that's valid. It's ideal to not keep wills all over. Try and make life simple, but that's the point. Is that the one with the most recent date is the one that is valid. Terence,
and Warren, you've touched on something there which is critically important from a bit of the technicalities, is please make sure you date your will. We've also seen people where the person drafting the will has signed it, they never got witnesses, and they never dated it. It's not a valid will. So please ensure that you have 2 witnesses who are not mentioned in the will and who don't benefit from the will, so completely independent people, to witness the act of you signing it. They don't have to read the will. They don't need to know the contents of the will. But the 3 of you need to sit together, have a cup of coffee, and all sign that will and write there where you've signed it, so Johannesburg, Cape Town, wherever it might be, with the date. And do this on every page, the signatures, and on the final page, date and place.
It's a key point. The wills have a few kind of rules, and that's definitely one of them. The witnesses not related to you in terms of getting something from the will is key, and that they actually did see you sign everything, and then the date, as Terence says, a PowerPoint there. Terence, we ask every guest when they've come onto Honest Money for the first time our favorite question, which is and just to brief you already, it doesn't need to be specific around wills or around money. It can be anything. But if you meet 21-year-old Terence now today, with the benefit of everything you've learned in life so far, what would be the one piece of advice you would like to give our young Terence?
Invest 25% of your salary straight away.
Every day, every month.
Every month, 25%. Get used to it. Just do it. It'll hurt for 2 or 3 months, and then you'll forget about it. And just let it go monthly, and let the power of compounding take over.
Terence Tobin, he's the founder of Rich Ideas, all-round good man, and your source of a free will in Wills Week. I appreciate you coming on the show and being so willing to help people out there and to share your knowledge. It's great to have you.
Thanks, Warren and Honest Money, for all the great stuff you do for everybody, and let's keep changing lives.
Brought to you by Prescient Investment Management. Informed by science, guided by insight. Prescient Investment Management is an authorized FSP